illusion. Understanding the 25-mile rule illusion with attorney Tom Dean. Important. Although the 25-mile rule is an illusion, it has become the status quo. This means that until we resolve these issues in court, it is still unlawful to cultivate without authorization on your medical marijuana card.
Clearly, I think if you talk to patients as a whole, the one issue that is most offensive is this 25-mile rule, so-called, that was invented, in my opinion, by the Department of Health Services way back when they promulgated regulations to implement the Medical Marijuana Act. Back then, no one was really talking about anything called the 25-mile rule. There is some reference to 25 miles in the Medical Marijuana Act, specifically talking about when a person lives more than 25 miles from a dispensary, they gain the additional right to designate somebody to cultivate marijuana on their behalf. But nowhere in the Medical Marijuana Act do we find, that's the act, the piece of legislation that the voters passed, the Medical Marijuana Act. Nowhere in there do we find this restriction that says that a person who lives closer than 25 miles does not have the right to cultivate. So it happened when the agency, the Department of Health Services, sat down and started writing regulations. Someone obviously got through to them and impressed upon them how important it was that they restrict home cultivation, that they restrict the ability of patients to cultivate. It's no secret that this is far and away the greatest concern of law enforcement, the thing that bothers the government the most. And some would say also is what bothers some dispensary owners are very upset by home cultivation, because for obvious reasons. A person who grows their own marijuana doesn't have to buy it from them. So whoever it was that got through to the bureaucrats over at the Department of Health Services, they decided to invent this 25-mile rule, and you can see it there in the regulations. But these regulations cannot, an agency, it doesn't have the power to just write whatever regulations that they want. I mean, the legislature has the right to pass laws, but agencies, departments only have, their job is to implement the laws that have been written. And they do that through rulemaking.
What do people have to do to push back and gain our grow rights back?
Well, I think that there's a couple ways that you can go about it. I think that probably the most effective and most efficient means would be to start out at the administrative level. So you request authorization to cultivate, you live within 25 miles, you're obviously going to be denied. Then it would be an administrative appeal of the department's decision to deny you that authorization, and ultimately then appealing that decision into the Superior Court, and if necessary, even the Arizona Court of Appeals. So when you start at the administrative level, you have the right to appeal the case all the way to the Arizona Court of Appeals. And the issue has to be raised correctly. It has to, it's very important the way that you phrase your arguments and your issues so that you effectively capture that issue, because what you're essentially arguing is that the department abused its rulemaking power by passing rules that are not authorized by the Medical Marijuana Act, that are not related or necessary for them to implement. In other words, they're just legislating from the agency. This was what happened, we talked about before, way back in a case from about 4 years ago, where the agency had made rules saying that dispensary owners had to, for example, be current on their taxes, current on child support, and couldn't have declared bankruptcy and these other rules. And a dispensary owner challenged that, and the Superior Court judge agreed. He struck those rules down because they were an abuse of the agency's rulemaking power. So that's basically exactly what you'd be asking the court to do in this for this issue too. So in other words, we've already had a case that successfully challenged the department's rulemaking authority in the Medical Marijuana Act and won. So we just need to repeat that, but in this particular issue.